Hello, everyone, and thank you for joining me. I'm Jill Bloom with Roofing Contractor, and welcome to our Best of Success podcast show. It's always a great day when I have some time to spend with Trent Cotney, partner of Adams and Reese. Trent, it's always great to see you. Thanks for joining me.
Jill, it's good to see you as well.
Well, it was a big week last week, Trent, for the Supreme Court rulings. A lot to unpack there. What does everybody need to know?
Yeah, so series of really big Supreme Court rulings. I'm going to focus on the ones that impact construction, and those are the three immigration-related ones. So first one to note was a decision that came out on June 25th, 2026, that dealt with temporary protected status, or TPS, and a lot of contractors and trades have workers that are working for them that are on temporary protected status. This case, it was Mullen v. Doe. That case, they looked at temporary protected status for Haitians and Syrians that were over here. And the court basically said that DHS has a lot of discretion when it comes to determining whether or not to revoke TPS protections. They basically said temporary means temporary. So if DHS decides to revoke something, they can do that. Now, what's interesting is that deals not only with Haitians and Syrians, but anybody that has TPS status. So regardless of whether you're from Mexico or Guatemala or somewhere else, what this ruling says is that if DHS decides that they no longer want to give temporary protected status, then they have some ability to do that. It was a win for the Trump administration in that regard. Second ruling also came out on June 25th, and that one dealt with asylum. As we had a lot of immigrants coming through the southern border and claiming that they were seeking asylum. And the question really was, at what point are you allowed to seek asylum? Is it before the point of entry, at the point of entry, over the point of entry? And what the court ruled is it said it gives the executive branch more discretion in controlling access to asylum, and basically said, the executive branch, the DHS, can say you can't claim asylum until you're actually here. So if you're stopped prior to the border, asylum doesn't necessarily work, right? And it scrutinized some of the migrants that were seeking asylum or abusing that process. And the last one I'll mention, Jill, was birthright citizenship. So we had two wins for the Trump administration. This was a loss, but not unexpected, right? Birthright citizenship is contained in the Constitution. Basically, under the 14th Amendment, it says that if you're born here in the United States, even to people that are not here legally, that you are entitled to citizenship. On January 20th of 2025, an executive order was entered by the Trump administration, basically saying that they were looking to revoke that. From a strictly constitutional standpoint and a legal standpoint, this decision probably makes sense. You can't completely eliminate it via executive order. You could potentially change it via Congress. You could change it via constitutional amendment. But what is interesting, if you read the opinion, and the opinion's like 180 pages, I think I read, maybe 80 of that 100. It says that there are other ways that you could potentially control this. So one of the big issues that came up in this case, and this is fairly interesting, for our listeners, was there was a concern about birth tourism. And it said that
Right.
executive orders could potentially curtail that, or Congress could potentially curtail things. The only thing that you can't actively attack is birthright citizenship unless you have Congress or an amendment to the Constitution available there. So interesting ruling. This was not unanticipated. I think everybody, including the Trump administration, probably believed that this was going to come. But all of these issues, why is this important? Immigration and labor is always the top of mind for any contractor in trade. And these rulings, obviously impact our labor force. So
Yeah.
I think recognizing that, understanding that, keeping in touch with it, I think is a critical thing.
So let's go back to asylum for a minute. So
Yeah.
are you saying that if people are already here, they can still claim asylum?
So they can go through the
They
process of
can't.
this. Yeah.
Okay.
Yeah. So let's unpack it a little bit. So this
Yeah.
case was Mullen v. Al Otro Lotto, and I'm sure I've murdered that pronunciation. But and what happened is the court actually looked at what each side was saying, and they sided with the government in the challenge. They said that certain metering practices that the southern border points of entry were handling. That when you look at that, when you're bringing people on, you can assess asylum at various points. And what the government was saying is like, look, in order to receive asylum and inspection, you can't do that outside the United States, right? So if you are stopped before you get there, you can't seek asylum. The practical effect of this is that the ruling gives the executive branch a ton more discretion in controlling access to the asylum process at ports of entry. And that's a key thing because this is, at least in my opinion, is probably the number one thing that's sought by a lot of, the migrants that were coming over was they were all claiming asylum. And asylum, historically has had a very narrow definition. You typically think of war, political prosecution, things like that. If you're, coming from Argentina, there's not a lot of reasons to claim asylum, right? So,
Sure.
Not singling out Argentina, but I was just watching the FIFA match, so that's what made me think of it. So,
Okay. Yeah.
so
They just wanted to come watch the game.
yeah, exactly. That's not a basis for asylum. So that kind of gives you an idea there. That is all of this is from a legal standpoint is very interesting because these are issues, a lot of which were kind of taken for granted, but the courts are getting very granular with the analysis,
Hmm.
especially on the temporary protected status and the asylum.
So you can't claim asylum on your way in, but if you're already here, you still
They
can.
can, what it said is they can determine at what point you have the
Okay.
ability to assess asylum. So if you are stopped, I'm giving a hypothetical. If you are stopped
Right.
25
Okay.
feet before you hit the border or the port of entry, you can't claim asylum, right?
Step over the border, you can.
Yeah, yeah. I mean, you can potentially argue. It doesn't mean you're entitled to it.
Right.
But what the administration is looking to do is to curtail the abuse of the asylum process, right?
Yeah. It clearly
Everyone's
was an
claiming
abuse.
asylum. Clearly, there's not everyone's entitled to it. So,
So, with all these rulings that just took place, Trent, is this going to what does that have on the effect that contractors are kind of managing right now with just ICE in general? Is that going to help any of that? Is that I mean I realize they're totally different, but I mean
yeah.
for a long time we were hearing at trade shows that there was especially people that are in different parts of the country that some of these owners were having their crews that were just afraid to show up to work.
Yeah, and I think, what I take away from these rulings is that the court gave substantial deference on certain things like, temporary protected status and border asylum processing to the administration, to DHS, but it drew the line at constitutional birthright citizenship. What these rulings do is they strengthen the executive authority over immigration enforcement. So you can anticipate that, whether it's ICE raids or I-9 audits or, border protection, that's going to continue and it will continue to be an issue for construction labor to navigate. We depend on foreign labor, as does hospitality and agriculture. So navigating
Mm-hmm.
those, finding, a legal way for workers to come over here is still going to be a priority, in my opinion. But what these decisions basically do is, they are giving some discretion to DHS as far as enforcing some of these things. So,
Got it. Well, thank you for unpacking that. Another thing I think is really important, separate to this, is just the heat that we've all been dealing with.
yeah.
A lot of people are doing across the country, and there's some things that we also should probably unpack about that.
Yeah, absolutely. There's been some record heat. The Chicago area, Northeast had a lot of issues with it. If you're not used to it, it can sneak up on you. I'm from Florida, so I'm kind of used to it a little bit. But, I think as we've kind of talked about before, on the federal level, there's been an OSHA heat rule that's been, percolating for years now, right? And as it stands, it's kind of, stalled a little bit. The last thing that was of substance was, I believe, in April of this year. OSHA basically updated its national emphasis program and indicated that heat would be part of that for the next 5 years. So, what is the takeaway for contractors? Navigating heat illness and injury is a critical thing. Just because there isn't a federal rule that necessarily directly deals with it, you can still be cited under the general duty clause. So you need to update your heat illness plans. You need to provide water, rest, and shade, training, emergency response and monitoring, acclimatization. If let's say have worked up Northeast all your life and all of a sudden you're in Arizona, obviously there's different heat there that you need to be concerned about. And the key thing, like we always say, Jill, document, document, document. So one of the things they're going to look at is to see what kind of training, what kind of, policies and procedures you have on protecting your employees from OSHA heat, injury, and illness.
Yes. The famous statement from Trent Cotney, the one with the best paper trail always wins.
There you go. You got it.
And the last thing, Trent, is there anything else coming up? Any other rulings that you see that could be happening in the next 2 or 3 months that could also affect the construction industry, whether it's roofing or drywall?
Yeah. I think there's a handful on the Supreme Court level. There's a handful of these immigration, subset type challenges. Keep in mind that, I don't know what the exact percentage of cases that the Supreme Court actually hears, but it's very, very, very small. So there's a higher likelihood that the Supreme Court will not look to hear some of these cases, but you can anticipate that there may be some additional decisions where, the extent and enforcement of DHS and ICE will be challenged. That will further, create guardrails and indicate kind of, where executive power meets, constitutional issues or authority. On the state level, where we've seen a variety of challenges to everything from, some of the new laws governing pay it paid clauses. We've seen a variety of different laws that have challenged even local heat, injury, and illness rules back on that topic. A few years ago, Miami-Dade came out with a local rule that dealt with OSHA heat, injury, and illness. And, one of the things that was important was to say, look, we don't need a law every time we cross a county line, right? We need to make sure there's something uniform. So the answer is yes, there is always stuff up for grab, especially in this climate. You will see constant challenges that impact. The biggest things that affect construction right now, in my opinion, are going to be stuff that deals with tariffs and immigration. There are some additional tariff challenges that's still kind of up in the air after the recent Supreme Court decision striking down the use of the Trump administration's IEEPA tariffs, which are basically for national emergencies. So I do think that you will see some additional rulings on that, regardless of whether it's on the Supreme Court level or maybe a lower court. So stay tuned for that.
Sounds great. We absolutely will. Well, if anybody has any questions for you, Trent, how do they find you?
Sure. Well, they can hit me up via email, trent.cotney@arlaw.com, or anywhere social @Trent Cotney.
Excellent. Well, thanks again for your time, Trent. We always appreciate how open you are with insight and ideas for everybody listening. And if anybody has any questions for us, it's either roofingcontractor.com or wconline.com. And make sure you sign up for all our free content. Stay safe and healthy, and we can't wait to talk to you soon. Thanks as always, Trent.
Thank you.